All right, it is great to be with so many familiar faces and many new ones today. Most of you know who I am, so we'll spare you one more FedSoc introduction. My name is Beaton, and I'm a district judge in town and have been involved in these events probably as long as they've been happening in Kentucky. I think we have one or two other co-founders of the Northern Kentucky FedSoc chapter, lawyers chapter with me, who are here in the room from several years ago. What I have been up to while you guys were thinking big thoughts with Judge John and our distinguished guests, I was trying to get a multi-defendant jury trial through its proof and into jury instructions today. So I say that by way of excuse, if not introduction. Whatever scholarly prep you heard from your moderators, your judicial Sherpas, the last couple panels, don't expect that from me. Fortunately, we have an abundance of scholarly credibility up here on the stage with our most distinguished guest on the other side of the stage from me, Professor Judd Campbell of Stanford Law School, though he's currently in New York visiting at NYU. And it's our great good fortune that he has wonderful family members here in Kentucky, or at least wonderful enough to pair a visit to us with a visit to them. And we're delighted that he's here. Professor Campbell is a legal historian. Is that accurate? And he's written a lot on originalism, although finds areas where he doesn't always agree with others who adopt that titles. He's written on the history of rights, First Amendment, Second Amendment, 14th Amendment, teaching about property and all manner of interpretation. And I am told by some crack, or what I hope is crack advance work from Chambers, that he has a woodworking shop in his home. And so that's the teaser I'll leave for the cocktail hour. And you can address that as you see fit. We realize that we are your last engagement before cocktail hour and racing. We will bear that in mind as we monitor our pace. But that's a pretty nice way to end a Federalist Society chapter conference. So on that note, in particular, welcome to Kentucky. Judd. I'll sit down now. All right, can you all hear me now? Did they switch over mics? Yes? Okay, great. So the title of this panel is Litigating Originalism, and we'll see how well that works since neither of us is a litigator at the moment. But boy, is this fertile. Is this an interesting time to be studying all these debates about originalism in theory that have been mooted for the last 40 years, the whole lifespan of the Federalist Society, and now they are put into action more than ever before, or at least in the last century, I think it's fair to say. I'm going to borrow a prompt from a really good Federalist Society panel I heard maybe a year ago, and toss this question to you. I don't think you were on this panel. But the question was, how originalist is the Supreme Court today? And there's, of course, an embedded question about how you measure that. It's a 9-member body, and et cetera. I will give you all sorts of scholarly license to deal with that as you will, but very curious to hear just a level-setting question about where are we today when you think about litigating originalist arguments at the Supreme Court?
Yeah, thank you. Well, it's a delight to be here. Thanks, Judge, for the kind remarks. So I'll just say I was planning on giving a trigger warning at the outset that I have some things to say that are somewhat skeptical about textualism. But I see now in the program that we're having this fireside chat, so I don't need to be too worried about textual literalism. We've got...
Trackside chat.
Yeah, so I mean, I think in some ways it's a good time to be a lawyer and a professor and even a judge thinking about these problems involving rights because the Supreme Court has made things complicated enough that there is no way that ChatGPT can do this. We've got some job security. In terms of thinking about just kind of where we are and how that maps up to questions about originalism, we're in very different places with respect to different rights provisions. So the court, if we just go through thinking about free exercise, free speech, establishment, and gun rights, has taken radically different approaches. So with respect to, let's start with free speech, they've taken a sort of moderate anti-discrimination approach. So they're focused on whether the government is discriminating on the basis of content and viewpoint. And it's moderate in two respects. So one is that it is allowing for some forms of non-discriminatory governmental interference with speech to nonetheless trigger some degree of judicial scrutiny. This is O'Brien. And then on the government discriminatory end, they actually do allow for some governmental interests to come in and take priority over speech interests. So the paradigm is mostly a paradigm of non-discrimination, but with soft spots on each end. And for the most part, it has absolutely nothing to do with original meaning. There's just a ton of case law that's developed from very foundational decisions, mostly starting in the 1960s. The O'Brien case is one of those, that lay out this neutrality-based approach, different tiers of scrutiny for different types of restrictions. Then layered on top of that is all sorts of other doctrines like public employee speech cases, the cases involving public schools, the cases involving public forums and all that. So I think for the most part, with a perhaps interesting exception that we can delve into dealing with unprotected speech categories, the court has mostly been non-originalist in that area. And with little indication that they're shifting, maybe except for in the unprotected speech categories. With respect to the free exercise clause, there's sort of two ways of characterizing where they are now. So one is a much more robust anti-discrimination paradigm, which is to say, on one end, they just categorically reject that non-discriminatory statutes or applications of statutes trigger any form of heightened judicial analysis. This is the Employment Division versus Smith case. And then on the other end, they've embraced a really robust vision of what can count as a discriminatory provision and what sort of governmental interests are capable of taking priority. And this is the most favored nation cases that came out largely of the COVID era. And so this is a paradigm that the court has tried in some ways with very modest success, I would say, to defend on originalist grounds, but for the most part, it's reflective of a jurisprudence that's coming out of cases in the 1990s and onward. Then we have, in the Establishment Clause area, a rejection of the 1960s and 70s case law recently in an effort to be much more originalist. And the approach they've started to take is to say, we're going to look to the original meaning of what an establishment of religion was and say that the First Amendment disallows us from doing that. And so the basic paradigm here is to ask, what traditionally was the government not allowed to do? So I'm going to say that again because it contrasts with the approach to gun rights. What originally was the government not allowed to do? So they're veering in an originalist direction in that space. And then with respect to gun rights, they're unencumbered by a whole bunch of precedent. They started in Heller just recently, extended into cases including Bruin and Rahimi. And the basic approach has been in Heller to recognize a right based on originalist analysis. In Bruin, to then say, well, we've got all these subsidiary questions we've got to ask. So what we're going to do is we're going to focus on the original meaning of the text, basically define a sphere of governmental authority that presumptively is outside of the ability of the government to regulate. And then we're going to ask whether or not there are historically grounded reasons why the government can regulate. So it's sort of the opposite of what they're doing in the Establishment Clause space. In the Establishment Clause space, we're looking for traditions that show us what the government can't do, whereas in the Second Amendment space, we're defining the text to say what the government can't do, and then the onus on the government is to come in and show us with originalist analysis of the practices of gun regulation at the founding, what is it that the government can do. And so I think in those last two areas, we see the court veering in an originalist direction. And it's interesting that there seems to be some tension in how they're approaching that. In both spaces, they're looking to traditions. They're looking to the practices at the founding that were thought to be constitutional or unconstitutional. But the way in which they're analyzing that is very different between the Establishment Clause and the gun rights areas.
I might push back just a little bit as someone who reads on these matters, but from a very different perspective from you, and question whether, like, are those two approaches really that different? Burdens are important.
Yeah.
We trial lawyers and appellate lawyers know that. But on the one hand, if you modified your articulation of those two areas, what the government can do versus what it can't do, what if we change the question just a little bit to, let's examine what the government was understood to be able to do and not be able to do.
Right.
And instead of articulating maybe an overarching test or answer or applying a burden in one direction or the other, we're just going to use our analogical reasoning and we're going to use our historical examples in order to elucidate the meaning of these textual provisions. And over time, we're going to be able to settle on some principles that will put government actions, challenge government actions on one side or the other. Is that, is that a too charitable way to think of the enterprise that the Supreme Court is undertaking in terms of text, history, and tradition?
Yeah, so I think it's fair to say that they think they're doing the same thing in both areas. They think they're trying to identify what it is that the founders expected of governmental power with respect to establishments of religion and with respect to gun rights. And whether or not the two methods actually map up onto each other depends in part on how much the burden shifting matters. So if you had a really, really strong body of evidence as to exactly what the government couldn't do under the Establishment Clause, and you had absolute clarity about what it is that the government can do under the Second Amendment, then I think that there are two ways of getting at exactly the same thing. So at a sort of conceptual level, I agree with that. I think where the rubber really hits the road, though, is that we don't have perfect evidence about these things. We don't know exactly what it is that the founders expected as to exactly what counts as an establishment or exactly what counts as a valid regulation of firearms. And so when you're in that space where you have uncertainty, the burdens really matter. Yeah. And I'm not opposed to the idea that different rights should be viewed in different ways. But I do think that it's worth flagging that these are different approaches and they have different implications for the way that in practice we cash out questions of original meaning. Yeah. I'll just say, to put my somewhat skeptical of textualism in this area cards on the table, I think that as a general matter, originalists have taken the very plausible view that the Constitution is the source of fundamental law. We should look to what that fundamental law meant when it was enacted. What is the fundamental law? The fundamental law is the text as enacted. That's the basic premise of originalism. The trouble here is that the founders thought that they already had fundamental rights. They thought that they had those rights as a matter of natural law. They thought they had those rights as a matter of fundamental customary law. And so in that world, the text is not actually the source of the right. The text is just an indication that the right exists. And one way we know this is how they thought is that they added an amendment that made that assumption explicitly clear. They said that the enumeration of the foregoing rights shall not be construed to deny or disparage others that exist. So it's an assumption about where rights come from that's very different from our own. And to my mind, that means it's a little bit dangerous to put too much emphasis on the text itself. If the nature of the right that they were looking to was a right grounded in natural law or a right grounded in customary law, it seems sensible to me that we would say, well, there's this text, but it's pointing us elsewhere. What does this other body law have to say about it? And so, for what it's worth, I think that the Establishment Clause approach is in better alignment than the approach that they've taken in the gun rights case. But the kind of bigger point is they're plausibly different if we're in a space of uncertainty. And you really do want to think, if you're trying to approach as a scholar or a lawyer or a judge, how you think about this. You want to think about, well, what was the role of the text? What was it doing? And if I'm right, I think it points in one direction. Of course, I might not be right.
Well, this is interesting stuff, and I hope we're not nerding out too much for this hour of the day. But again, I'll come at this from a what's it all mean perspective. Let's say you're right descriptively that Madison and company thought, we're not creating a right to free speech. There is in the ether a right to free speech, and by golly, the Englishmen got it, and we have it too. But we're going to write it down anyway, because these pesky anti-federalists are going to make us. So if you come into court, whether this was 1793 or 2025, would the prudent, honest, principled originalist lawyer say, Judge, protect me from this vaccine mandate, religious tax burden, FACE Act prosecution, because I have a free-floating, pre-existing right to free expression? Or would the lawyer come in and say, we all know what the free speech meant, so did Madison, and so did Blackstone, and I'm looking at the First Amendment, and that's where the protection for my conduct from this emanates. So do you see a difference, as someone who sounds at least natural law curious, what is the difference when you're litigating originalism, and you step in from the natural law-ish perspective and say, I'd come in from a more positivist perspective?
Yeah, so there are a couple answers. I mean, one is that they thought that natural law was largely underdeterminate. So they didn't think natural law was a full set of particular rules about exactly what you can do and what you can't do. Rather, they thought it was a set of principles. And what that meant is that you needed somebody to cash out what those principles mean in application in particular situations. And for the most part, they thought that that responsibility lay with the people themselves through their representatives. And this is one of the reasons why they insisted over and over again during the ratification debates and the debates over the Bill of Rights in the first Congress, both the Federalists but also the Anti-Federalists, that it's absolutely essential for the protection of rights to have well-designed legislative institutions. We can't trust other actors. This is mostly up to us to decide. Now, the Federalists and Anti-Federalists had very different visions. So for the Federalists, they thought well-designed legislative institutions, well, where are those going to be? They're going to be at the national level, where we can create distance from the sort of parochial politics at the state level. And the Anti-Federalists say, well, well-designed institutions that represent us, that's local, because that's us. And anything that's too high up, too far away, is going to lack that representative capacity that we need in order to regulate and protect our rights. So it's absolutely essential to understand how they thought about rights, that they principally thought about rights protection in the legislative process. And that's why the design of the government, why questions of separation of powers and federalism, bicameralism and presentment and so on are just front and center in their thinking. That doesn't mean that judges don't have any role at the founding. They did have a role. And so what was that role? Well, to some extent, judges had the ability to come in and say, well, this statute, which seems, just looking at its text, to allow for an abridgment of a particular right in a way that just doesn't make sense probably doesn't mean that. The legislature didn't mean to take away your ability to exercise your religion by passing this general statute. So we might construe that statute in particular ways to say, well, even though the government has an ability to provide subpoenas that require evidence, we're not going to apply that statute to a Catholic priest who received information during a confession. So there's an ability to make that sort of argument. There's also an ability to make an argument that through the recognition of what our rights are in common law, in the law that we have come to accept as fundamental in our system, we've already recognized certain determinate limits on the government's ability to regulate. Now, a lot of those limits are actually specified in the Bill of Rights, which is why they wrote them down. They understood them to already be determinate limits. So the rule against prior restraints, the right to a jury trial, the right to confront witnesses, the rule against cruel and unusual punishments, and so on. But it's possible to make arguments at the founding that there are other rights. So for instance, if there's a general statute that bans you from exercising a right of self-defense, you might be able to come into court and say, this statute has taken away an unalienable aspect of my liberty that the common law has always recognized as fundamental and as inalienable. And so that sort of move is available. Not all judges at the founding would have bought it. There is a debate at the founding about the extent to which judges should identify limits that are unenumerated. But the idea that your rights are coming from the text is for the most part inconsistent with the way that they're thinking about the text. That doesn't mean that you can't point to the text as evidence in some cases. So sometimes the text will delineate certain things about the right that might give you a better idea of what exactly your rights are. I would just say for the most part, Madison, when he designed the Bill of Rights, was pretty deliberate in avoiding textual specification. So there are a lot of provisions at the time, Kentucky has one of these in its 1799 Constitution, that say a lot about the freedom of press and of speech. The Bill of Rights does not take that approach. All it says is, Congress shall not abridge the freedom of press or of speech. So I think it's the type of provision that actually gives you very little to go by, which is one of the reasons why I think focusing too much on the text in these cases is often not going to be very helpful.
So my old professor, Henry Monahan, RIP, used to make the point that originalism was great at ruling out arguments, but not so great at specifying outcomes. And I think he could make a very strong case for that position. I'm reminded that as I hear you talk about what I believe you consider sort of litigating moves and judicial moves that would be faithful with how courts and Congress and state legislators would have thought through these issues 250 years ago. But boy, it doesn't sound terribly constrained. And as someone who came to FedSoc as a good left-brained, constraint-minded, syllogistic legal thinker, this is a scary new world that you and other would-be originalists like our friend Will Bode are showing us.
Yeah.
So, I mean, is there really much difference in originalism, and you may say as practiced by the likes of Marshall and Madison, and this sort of constitutional pluralism that would be readily embraced by Professor Fallon or Professor Wexler or the sort of moderns that Scalia and Bork thought they were refuting when originalism emerged on the scene again?
Yeah, so I think that there's a big difference between the basic attitude that the founders had towards constitutional law and what we expect of it and what we expect of judges, and what developed in the Warren Court and has for the most part stuck, which is the attitude is a lot of constitutional content has to get worked out through politics. That's an expectation at the founding. And that's not part of our current culture. So whenever we see an open-ended provision now, we sort of assume, well, that provision has to either get fleshed out based on our efforts to discern what the founders thought, or it has to get fleshed out by judges based on some sort of policy analysis. And the sort of missing alternative in that is that there might be other ways of recognizing constitutional content. So at the founding, that would have been in part based on legislative decisions, as I was mentioning earlier, which is not exclusive, but it's definitely a big part of their culture. The other big part is through the gradual accretion of common law decisions, through customary law. And one of the things that's critically different between our sort of modern attitudes about judge-made law and founding era attitudes about common law is that for the most part, the founders didn't think that common law was something that judges made up. They thought that common law was something that we could recognize over time, learn more things about, add data points to as we decided cases. But it's not a sort of judicial form of positive law. And that's a really big shift from what we see in our modern legal culture, where we just have come to think about what it is when judges make decisions in spaces where the text doesn't provide an answer as a form of lawmaking. And I don't know if that's a sort of vision that we can unsee. It could be an insight of realism that is true and that it's impossible to go backwards. But it's a really big difference between the culture of judging at the founding and the one that we've generally come to accept now.
I'll ask one question about litigating, since that's the title after all, and then I will see if there are any hands for questions in just a moment. So if you are a busy public defender, state court prosecutor, if you're litigating constitutional rights in state supreme courts, representing one of these great commonwealths, to what extent are these originalist arguments all now at least superficially in bounds? Are they really available to you? Do those of us who used to or still do write down our time in tenths of an hour need to say, oh, I'm going to the stacks and I'm going to go deep on this privileges and immunities issue, or I'm just going to read Professor Campbell's latest argument? Or are we in a world in which really the only people who can do originalism, who can litigate originalism, are professors writing amicus briefs or public interest groups with less time constraints and less funding constraints, Supreme Court justices who only have 44 cases a year? What does it mean for the way these arguments can realistically be raised today?
Yeah, I mean, this is a big problem for the court's effort to revive some form of originalism, as it requires a lot of different actors in the system being on the same page, actually making the efforts to try to uncover original meaning. One of the biggest factors in this is whether the legal academy has people working on the problems that matter, which I think is probably a viable thing at the national level, and is just woefully inadequate at the state constitutional level, where there's just not a lot of focus in the legal academy. But I think that looking to academics is an important part of this because there's a division of labor problem. I think it's a problem that is more acute under a certain approach to these questions than it might be under another. So in the Bruin case, the Supreme Court decided that the Second Amendment should get its meaning by looking to the text of the Second Amendment and then trying to identify any historical practices that would allow for the government to regulate in the way it wanted to regulate. Rahimi is the subsequent case, and the court says, well, we're not just going to look to the practices, we're going to look to the principles. And if you make that move, it takes some of the pressure off the research side. But what it does is because you no longer have to have a minute understanding of every gun regulation, now we can operate at some higher level of generality to resolve some questions. And that move is helpful for lawyering as the case law accumulates and as the academic scholarship accumulates, because it's going to allow us resources to point to try to address problems that might not be addressed at a sort of minute level at the, in the historical scholarship or in the old case reports or statutes or what have you. What that move does, though, is it introduces a different problem, which is an effort for judges and for lawyers to make arguments by analogy. And so that's the very problem that the court was concerned about in Bruin. It's the very problem that Justice Thomas is especially worried about, that we would have judges engaging in ends-means analysis, sort of policy-based analysis under the mantle of either intermediate scrutiny or strict scrutiny. And the difficulty in Rahimi, even though it takes some of the pressure off of the historical research side of things, is that it reintroduces a question. They don't call it ends and means, they call it how and why. But means and ends is just another way of saying how and why, and then you have to get into arguments about the extent to which a particular analog in history reflects a principle, and that principle then gets cashed out in any particular way in the modern cases.
But there is a big difference between my assessment in 2025 of the legislature's ends and means, and do they tally up in an acceptable way or an unacceptable way, versus what was the principle of this decision. And these three decisions I see in the, going armed laws and so forth, fray laws and what have you. And if I can find a principle and I can understand it in terms of its how and why, that's at least surely moving beyond the bad old days of the 60s and 70s, because I'm not taking on myself as a judge to make the policy choice. I'm at least, if you ascribe good faith to the judges, I'm trying to understand what was the principle at the time. I'm going to assume there was fixity to it, and I'm going to extend it. That seems like maybe that's Pollyannish, but it seems to me like that's a step in the positive direction for the originalist side in terms of constraining, freewheeling interpretation and grounding it in something external to the judge.
Right, I agree with that. And I think it's a big shift from a mentality that dominated during the Warren Court, which is just all of this is policy balancing.
Yeah.
Unconstrained by a sort of grounding in some historical materials. So I totally agree with that. My point is that when we're thinking about the viability of doing this as a practical matter, that you face different sets of problems. Yeah. And one of the sets of problems under Bruin is the time and expertise needed to do the research. And I think that Rahimi takes a lot of pressure off of that problem. It doesn't end that problem. There's still a need to find historical materials, but it's taking a fair amount of pressure off of that. What it's then going to introduce is a problem of how to define what those principles are, what the how and the why is. Hopefully that will be done in reference to how people are thinking earlier on in our history, rather than how a judge today does. But that at least makes the enterprise of deciding these cases, I think, a bit more tractable for judges as and lawyers as the case law develops. So we'll have more materials over time to go on as to what exactly the how includes and what exactly the why includes. And there'll be less need for the sort of very, very fine parsing in the old dusty statute books and so on that we saw dominate the lower court litigation for the 3 years between Bruin and Rahimi.
Do we need questioners to go to the mic, or are we fine at the table? Mic is great if you're nearby. If anybody wants, or you can just throw up your hands. I'll ask one question while I wait on hands, sort of in loco parentis for the law clerks out there who would aspire to a career of scholarship and woodwork like yours, Professor. Will law schools hire people who want to just figure out real questions? I think our friend Judge Oldham wrote an article a couple years ago about like, why can't originalism research like answer real questions and give us thick answers, thick meanings. But anyone who looks at like the job market in academia, you wouldn't find a lot of hope there. So do you have advice for the law clerks and young lawyers here who might want to help people like me and follow in tracks like yours to answer these how and why historical questions?
Yeah. So, I think there are two things that are making this especially difficult 10 years ago. So one of them is a bias against originalism, which is a view that this is like doing horoscopes or something. So why are we going to hire somebody to do horoscopes? Another of them is a bias against doing practical doctrinal legal work. The first bias is still there, but it's less than it was 10 years ago. There's actually an interest in intellectual diversity in a lot of schools. Sometimes it's the tokenism interest, but I think that there definitely is more hiring in this area. But the second is still around. The interest in having scholarship of a particular sort that's not just replicating what it is that amicus writers do. And so what I would say is, and this is in some tension with the goal of having a sort of division of labor, but I think still it's a necessary tactical thing for younger people to do, is to write historical scholarship that has originalist implications, but not to focus on providing the one true right answer to the problem, but to ask as a scholarly matter, what is the evidence? How do I evaluate that evidence as best I can? Being open about the areas where you're uncertain, being playful with the ideas and counter-arguments and so on. And I think that that's the way to succeed as somebody who is writing from a somewhat countercultural from the legal academia side, is being somebody who has a sort of playful attitude about writing this type of scholarship. And therefore is able to not get typecast as somebody who's just writing amicus briefs from within a law school. And in my view, the master at this is Will Bode, our mutual friend, somebody who is writing work that is open-minded and very scholarly, very interested in sort of the puzzles as much as the answers. And that's an attitude, if you're trying to get into legal academia, I think it's good to emulate.
Well, that's great and hopeful. We've gone in 3 years from boycotts being announced at this convention to an invitation for all you aspiring law clerks and future professors. Send your thoughtful, playful papers to Professor Campbell, and you'll be on your way.
Yeah.
All right. Phil, question?
Yeah. So if we're in the text history and tradition space in originalism, what do you do with these moments of, call it contested history? Right? So what do you do with the free speech clause when the Sedition Act exists in 1798?
Yeah.
Written by a guy who was sort of in the room, around the room as the First Amendment's being written.
Yeah.
Where you have actually a sitting congressman going to jail for violating this.
Yeah. Well, I think one of the challenges is thinking about what is it that you're looking for? What's the goal of the interpretive exercise? So traditionally, the goal of the interpretive exercise is to figure out what it is the people who wrote the amendment thought that the government could do or not do. And I'm not sure that's the goal. I think the goal might be to figure out what it is that the freedom of speech entails and what it is that our customary law or our natural rights tell us about the freedom of speech. And the answer to that question might not be the same as the answer to the question, what did the founders think? Over time, customary law develops. And if we were in a world where we were looking to the common law, we would be in a world where we would not have seditious libel law. Because seditious libel law drops out of the customary law of the United States very quickly. We also would be in a world where we didn't have blasphemy law, even though the founders fully expected for blasphemy prosecutions to continue in states that had speech and press clauses. And so if we're just looking to the question, what did the founders think about this, I think it's very difficult to sustain an originalist jurisprudence that says the government can't prosecute seditious libel or can't prosecute blasphemy. I'm not sure that's the right answer, though. I think that it could be the case, if you're looking to customary fundamental law, that you recognize that the meaning of freedom of speech and the meaning of freedom of press aren't necessarily the same as what the founders thought about those concepts.
Question right here.
So, if I'm in front of a trial judge, if I'm making an originalist argument with commentary backing it up, debates, I can point to that.
Yeah.
Now, if I'm making an argument about natural law, commentary, principled arguments, I just imagine a trial judge looking at me and saying, why should I care about this? And I have to answer it in about 10 seconds,
Yep.
or she's going to be mad at me for wasting her time.
Yep.
What is my answer?
Yeah. Well, I think that this is one of those areas where the Supreme Court is several steps behind, several generations behind, where the scholarly and legal culture is. And that's just the nature of things when you have top-down decision-making by people who were brought up in a different legal culture. And so, I think you have a duty to your clients. And what that means is that you have to operate within the existing paradigms. That doesn't mean that as a broader matter, writing outside or speaking outside of your role as an advocate for your clients, that you can't think about and write about and talk about some of the implications for a different way of thinking about history. But yeah, I absolutely agree. As a matter of your professional duties, you have to work within the existing confines of precedent. And that makes the job very, very difficult for an originalist lawyer. So I was just speaking at Columbia on Tuesday, and the very first thing that I said is, it's totally fine to try this at home, just don't try it in court. It's an important warning. You can't go into court and talk about natural law. That might not be true forever. Culture changes over time, and we'll see what happens. But I totally agree with you. And I think it's one of the difficulties of figuring out what to do today as just an academic enterprise. How do you take older ideas that were embedded in a very different world, where they had different assumptions about morality and religion, about a sense of community and so on, and put it into operation in a world that doesn't share those assumptions? It's a really difficult problem. Erica?
Please wait for the microphone.
Oh, thanks.
How do you deal with incorporation as an originalist? Because, of course, the founding generation didn't expect the Bill of Rights to bind the states at all.
Yeah.
And that comes in with the 14th Amendment. So should you be looking to the original meaning as of the founding generation or the 1860s or both? And what do you do if the understanding changed in between those periods?
Yeah, so the answer as a doctrinal matter is we're not sure. The Supreme Court has at least identified the problem now, but it has done virtually nothing to help answer that problem. And it's a really big conceptual problem, and it's super important. What I would say is, historically, how I think about this, so this is not an answer for what you do in court, but just conceptually, it's a problem that the framers of the 14th Amendment didn't worry about. And they didn't worry about it for a particular reason. They thought, like the founders thought, that there already existed these general fundamental rights that already bound all free governments. They were the rights we inherited as Englishmen. They were the rights of citizenship identified in the Privileges and Immunities Clause of Article 4. And they were the rights that the writers of Section 1, John Bingham especially, thought that they were recognizing but not creating when they drafted and ratified Section 1 of the 14th Amendment. And so it's the same set of rights. The First Amendment rights are not coming from the First Amendment. The 14th Amendment rights are not coming from the 14th Amendment. Both of those amendments point to the same body of law. It's a body of law that consists of natural law and customary law. That natural law we come to better recognize over time. That customary law gradually develops over time. And so the tension between having to look to the original meaning of the First Amendment as opposed to the original meaning of the 14th Amendment just disappears when that's the way you think about where the rights are located. So it's just a problem that they didn't face because their assumptions about what rights were and where they came from was very different.
All right. Last question, over here. There's one right behind you if you want. I think it's on.
Okay, yeah, this is on. Cool. So, Professor Campbell, you started off your remarks by noting that the Supreme Court is becoming more originalist or trending toward originalism, at least in a subset of the Constitution's provisions.
Yeah.
And then the specific examples you gave involve jurisprudential evolutions towards history and tradition. And one of the observations about that move from original public meaning originalists is that it's meaning untethered from the text.
Yeah.
So is the Supreme Court moving toward a non-original public meaning originalism? And if so, what do you call that?
Yeah, so I think that this is a division on the court itself. So you have some justices who are really interested in tradition, not just in the sense of what was happening at the time that the amendment was passed, but what has happened since. And so some of the justices put a lot of emphasis on it. For instance, the Supreme Court had a recent trademark case in the First Amendment speech area dealing with the question of, well, how exactly should we define what the government's allowed to do when it imposes trademark rules that maybe are content-based. And the court in the plurality decision looks to tradition in a very extended way, including tradition up into the early 1900s. And Justice Barrett has a really nice concurring opinion where she says, wait a minute, what are you looking at all these decisions and statutes in the early 1900s for? That doesn't bear on the question of original meaning. And I think that there are kind of two ways of thinking about this. So one of the ways of thinking about it is, if you accept that there are some areas of underdeterminacy in the original meaning, you need a method for cashing out that underdeterminacy. So you've got unresolved questions. Well, now what method do you use to resolve the unresolved questions? We're stipulating here that they're unresolved based on the original meaning. And so I think that's where you see the fight between Justice Thomas, who I think is drawing on a tradition-based approach that Justice Scalia often used, saying, well, we don't want to look to judges' own policy views, so let's fill it with something else. Tradition is a better way of answering the question than judges' policy views, so it's a gap-filling device. And I think that's one way of using tradition that's consistent with originalism. It's not the same as originalism, but at least might have some role to play where the original meaning is unclear. The other way, which the court is not embracing in any of these cases, but which I think we should think about, is whether, if the rights are not themselves defined by the original meaning of the First Amendment, but the First Amendment, as originally understood, is actually pointing us elsewhere to a body of customary fundamental law, then maybe the traditions are useful in explicating exactly what that customary fundamental law entails. That's not something the Supreme Court has the conceptual vocabulary to say yet, because it has not read, much less agreed with anything that I've said or that Will has written about or what have you. But I think if we're trying to think about this from a sort of historical perspective, it's at least plausibly connected to my previous answer about how to think about what to do as an originalist. The answer might be the original meaning of the First Amendment points us somewhere else. Where it points us might be to a more tradition-based approach.
All right, you heard it from future Justice Campbell.
Oh my God.
This is the way. Thank you so much for coming. Thanks to everyone for being here. Such a great day.